we think these indicators are useful, so we want to have them. We want the gatekeepers to provide these types of indicators. We did not go as far as specifying them for now. And the reason for that is exactly the work you've been doing. It's because we want to receive more input, we want to have more experience.
So basically, we will start with a panel on process and compliance. I mean, this is a word that we have heard a lot so far, and Martin insists a lot on this, that it's a compliance law, DSA and DMA, and that could not be truer. So we have produced, in the context of the big report that we have published today, there is a number of issue paper. Each panel deal with one or two of those issue papers. So the one here are the one on process that was co-authored by Giorgio, Monti, who is here, and Richard Feasey, who is here. And then another paper on output indicators that was co-authored by Richard and me. So we will present this, and then we will have a discussion, and I have asked to all the panelists on site and online to be extremely brief, so 3 minutes max, and I will stop you after 3 minutes, where I ask you one thing you like in those reports, and one thing you think could have been improved, and why. And for that, we will do in that order. There will be first Carel Maske from Microsoft, then Georgios from Google, then we have online Fiona Morton from the Yale University, and also one of the big specialists of the DMA, and then we have Max van Thun from the Open Market Institute, so from the civil society. And then I will finish with Antoine Babinet from the European Commission, and then EMEA Fletcher, who was also one of the author of those reports and worked quite a bit on the indicator. So Giorgio, you have the mic.
Okay, thanks very much. Unfortunately, Richard Feasey is not here, and the best parts of the reports are his writing rather than mine, but I will do my best to explain how we approach the topic. So the first thing we try to explore is a little bit how the compliance process is expected to work. And we've mapped it out on this slide. I realize it's very small, so I'll just give you the highlights, which is that, in a sense, this first step is for the gatekeeper to decide for themselves what measures to adopt to comply. And then there are processes whereby some sort of ex-ante guidance may be obtained from the Commission, where ex-ante ideas can be obtained from third parties and stakeholders. We then move on from implementation to the assessment, where there is a template for the gatekeeper to explain how it has complied, a non-confidential report, which then allows for ex-post assessment of what the gatekeeper has done, and then the possibility of financial penalties. The way in which we see the DMA is to focus much less on the latter element, the financial penalties, and more on what we call in the report positive regulation. That is to say, to maximize the opportunities for compliance through self-regulation. And so what we try and do in the report is try to explore a little bit how this can be incentivized, and what extent both the gatekeepers on the one hand, third parties, beneficiaries of the DMA on the other, and the Commission can all work collectively to stimulate as much self-regulation as possible. And some of the issues that come up within the context of the compliance program suggest that compliance process suggests that this kind of self-regulation is probably going to be more valuable in delivering effective compliance than actually a punitive mechanism for regulation. So some of these are highlighted on these slides in terms of the novelty, the lack of certainty, and the difficult impact that sometimes we can see that the measures might have on third parties. Now, we discussed a little bit in the paper the process of specification which is made available. And we discuss a little bit the trade-offs between asking for specification on the one hand, which can be beneficial because it gives legal certainty, but can also be risky because it ties the gatekeeper's hands to a particular way that the Commission has decided to interpret that regulation. We also discussed the possibility of specification being requested before the deadline for compliance, and then the possibility for ex post specification, highlighting that this is the only way in which one can obtain some sort of certification for compliance. And other than that, the Commission is silent on how the gatekeeper ought to comply. Now, we also identify a number of questions in terms of how to determine whether or not compliance is effective. As has already been discussed during the day, it may not be possible to work out whether compliance is effective on day one. There may be some short-term solutions, some longer-term solutions. The market may evolve, technology might change such that compliance on day one may not be the same thing as compliance subsequently. It may also be difficult to understand what is effective compliance. There may be barriers to understanding that, which pushes us towards suggesting some sort of participatory dialogue before implementation. And let me just move on to the sort of the recommendations that we make to stimulate self-regulation, which in our view overcomes some of these difficulties. And the first is to suggest that the Commission produces guidance to both gatekeepers and third parties on how to improve prospects for compliance and reduce the risks for fines. And so some of the things in the report are fairly straightforward, such as transparency of dialogue, ensuring that third parties are able to complain to the Commission and are protected, but also considering the degree of third-party engagement in the way in which we assess compliance. That is to say, if the gatekeeper has actively engaged with third parties and has sought to resolve the issues, then that is an indicator of effective compliance. And then the second recommendation would be to create some sort of incentives by the Commission for gatekeepers and third parties to engage in this direct dialogue. So some examples of the kinds of incentives that could be created is that the Commission is more responsive to a specification decision from a gatekeeper when the gatekeeper comes up and says, we have discussed this compliance with a variety of third parties. We have different responses from third parties. We are uncertain how to comply. Please advise. And that would be an indicator for the Commission to be more willing to accept a regulatory dialogue than a different situation. Likewise, enforcement might be affected by the way in which gatekeeper conduct includes a dialogue with third parties, so to some extent to reward the gatekeeper that engages in dialogue and tries to resolve issues, and therefore stimulating an exchange before enforcement. And moreover, in terms of third parties, we also think that third parties should be encouraged to engage with the gatekeeper first before going to complain to the Commission. So in a sense, these are indicators of when it is that the Commission should intervene, and when the Commission could also give signals that it is better for the gatekeepers and third-party beneficiaries of the DMA to collectively resolve the issue before going to the Commission. And that's more or less the recommendations.
Okay, and then the other, let's say, part of the report regarding process is this idea that we suggest to have output indicators. No, I must say that it was probably the more controversial part of the project in a way. And so I first want to clarify what is the role of those output indicators that we propose. Those are not compliance indicators. So the point is not to say that if the indicator is not good or do not go in the right direction, that automatically means that the gatekeeper is not complying with its obligation. The point of the output indicator is to focus the mind of the Commission, the gatekeeper, and the business user on issue which may be problematic. Okay? And so the idea is to say that if an indicator is not progressing well, or if among different gatekeepers the output indicator of one is not as good as another one, then you have to dig further to understand why it is so. And it's only after having analyzed the case further that then you may conclude that, for instance, there was no compliance or the obligation was not appropriate and maybe the obligation needs to be changed. Okay, so I think that's very important to understand what's the role of those indicators. Now, what they are, wait, because I'm not sure how it works, this thing. Okay. So also another thing which is very important to distinguish is, in fact, if you think about indicators, quantitative indicators, you may think about three of them. You know, you may think about process indicators. So in the sense of what has changed in the process or in the design of the product because of the DMA. Okay, that's one thing. Another thing is output indicators. So that's what we are focusing on, is how far, for instance, the new choice which have been created for business user or for end user have been taken up by those users. And again, I mean, I repeat, if they have not been taken up, it may be because the choice was not rightly presented, or it may be because the user don't want to change. And then you have outcome indicators, which is, for instance, market share indicators, whether the market share of the gatekeeper will decrease over time, okay? So what we focus on is output indicators, see how much the different opportunities which are created by the DMA have been taken up by the business user in the end user. Now, I will not bother you with the list of the indicators. We proposed a long list of those indicators, but for instance, if you take Article 6, paragraph 3, which is about allowing an installation of app, the question is, for instance, how many people, how many of us will uninstall the app of the gatekeeper and go to something else, okay? So now, how those kind of output indicator could play a role in the compliance process, or in the process of the DMA implementation, we think that they should be reported by the gatekeeper in their annual compliance report, and in a way the Commission goes a little bit to this as well, and then, as the template is providing, at this stage at least, every gatekeeper can choose what kind of indicator they want, but we think that at some point and after some learning, it would be good that the Commission uniformize in a way those output indicators, because that would allow a comparison across gatekeeper, and that would allow a constant analysis of the evolution of those indicators over time, and we think that those two things are very important. Okay, so this is what I wanted to tell you about. We wanted to tell you about this process and those indicators. Okay, thank you. Now I take the other role, which is not easy. And so now I will ask you to react to all the panelists, to react to what you have heard and what you have read in the report. And as I announced, so I will start with you, Carel from Microsoft.
Thank you very much. Thanks for having me. And I'm supposed to say what I like and don't like about both of the papers.
Equally,
now,
equally.
There is a lot I like. And what I first of all like and congratulate CERRE for is, bringing together this project and provide more clarity. And then next to the Commission, which also is engaging in this process actively, and we are learning a lot as we are coming along. And I think some of that is reflected in the process paper. The active role that the Commission is playing and has to play in this process, I think, was clear to some from the outset, and I think all of us learned in the process that that's critical to the success of this whole project. It's very helpful, much appreciated, and an important factor to ultimately make that work. It's a little bit the discussion around, self-enforcing or not, obviously. As we all notice, there are huge challenges in implementing some of that, and the discussion helps. The other piece I like about the process paper is the role of third parties, and that's an emphasis which came out also in the engagement with the Commission around implementation of the DMA, how critical it is to involve feedback from third parties. What I don't like so much is whether at the end of the day it's the most squeaky wheel that we should focus on. It's probably not the right approach, but there is some challenge with that feedback process, obviously. As a gatekeeper, by definition, you have probably some 10,000 business users. You have 45 million users. That's a lot. How do you organize that process? How do you collect that feedback? And obviously, the interests of these users are not aligned. Business users have other interests than end users, but also the users between themselves are not aligned. Different users have different interests. So there is a huge challenge around that, that process, how to manage it, how to collect that feedback. I mean, as a product developer, you have some standardized processes to collect feedback, but you typically do that with a very targeted audience, and it's a subset of people who are ultimately using the product. It's the people who are engaging more with the product and have probably their own interests, which might differ. So that's about, and I'm also supposed to speak, or can talk about indicators?
Yeah, please.
Because indicators might take me a little bit longer, and I'm sorry that I might exceed my 3 minutes on those.
Not too much.
No, but I mean, again, what I like, I think it's trying to create some accountability in that process and make things comparable. But, I mean, chapeau, Alexandre, for taking this on, because it is incredibly difficult. First of all, you know, understanding what these indicators are supposed to do and not, because that's very, very confusing. And there are helpful things, obviously, to track. You know, you can track the number of choice screen that you are showing, or the disputes that you have, new app stores being installed, ISVs using third-party services. All that makes totally sense from my perspective. But also, when you then think about choice screens, what does that mean? You know, if you offer a user a gatekeeper product and 3 other products, that user will choose the gatekeeper product. You know, that's at least our experience, how it works in some markets. So what do you then do with the data and also the process over time? How do you evaluate it? And ultimately the question, you know, what does it then help? You know, if you then need to go into the analysis, what that means, and then ultimately say, yeah, but it means many things. But uninstallation on Windows, people could for years uninstall products. We are not counting who's uninstalling it. We don't know if someone is no longer using a certain product. We don't know, you know, what happened to the product, whether it's broken, whether it's uninstalled, whether the user just doesn't like the product anymore. And what does it mean? You know, in terms of, you know, more contestability. And the objectives of fairness. The consent under 5.2, you know, if you give a user a choice, if I'm asked whether someone can use my data for something or shouldn't, I say no. Why should you use my data? Yeah, it's great to have that choice under the DMA, but what does it mean then that people are doing it or not doing it? If 100% don't give that consent, we know, yeah, that's probably the behavioral bias you have, even if you're trying to convince users that's important to have that data shared. If you have, you know, a certain percentage that give that consent, or everyone is saying, you know, why not giving consent? You know, I'm getting more targeted advertising, it's helpful for me, someone is able to sell that to me. Yeah, it might be, you know, there is no value in, you know, that protection of data that is perceived by the DMA. So for the compliance and what we are doing under this process is a very difficult and difficult question. One last point on indicators which struck me is the question, should we actually track other things? There is one indirect factor that is interesting. For example, the cost of advertising. We are having probably an advertising monopoly or a strong concentration in advertising. That is a concern that's supposed to be addressed by the DMA. Cost of advertising could be an indication that advertising, there's more contestability. What the DMA probably does is make search inventory more valuable than social inventory, because you can't share that anymore, you can't target as well on social, but if you have enough search data, you know exactly what the customers want, and advertising, you can target better. So I would assume advertising in search is becoming more expensive, advertising on social media is becoming less expensive. Then again, it raises the question, even these factors, which might be an indirect indication of more competition or competitiveness, might be the result actually of the effects that the DMA produces unintendedly. So all this is to say, you know, it's a great first step to try to think about these things and start the discussion, and appreciate having this discussion. But there is quite some challenges. I think user satisfaction would be another important one that maybe we should track. Maybe we should also track malware incidents, whether they go up as a result of data sharing or whether they go down. I mean, some gatekeepers would argue they go significantly up. They are concerned about security of their platforms. So I think that's also something maybe, you know, to complement that, to think about and discuss. Thanks.
Thank you very much, Carel. We will reply at the end, but Georgios, please.
Yes, thanks, Alexander. I do still have my 3 minutes, right? Or,
3 minutes, okay. Yes, but no more.
Cool. No more.
Don't follow the first mover advantage.
No, we cannot. We cannot follow the most valuable company in the world, right? So now, I mean, first of all, thanks for having me here. I think our discussion today centers around processes, and I'd like to commend CERRE for the approach in forging a consensus among members who do not necessarily share the same perspective and objectives under the DMA. And I think this process that took some time serves as a lesson for the ongoing discussions on the DMA, especially considering the potential for polarization on these matters. Now, as you have rightly said in your enthusiastic presentation of the indicators, among others, Alexander, a central point of contention has been around defining the metrics or indicators of success, specifically determining the threshold at which the efforts of a gatekeeper is deemed sufficient, or the efforts are deemed sufficient for compliance. Now, the DMA stipulates something that Mr. Grillo said, stipulates that for gatekeeper conduct to be compliant, it must effectively fulfill the objective of the relevant rule, but at the same time reach the overall objective, the overarching objectives of the DMA, which are to enhance market contestability and eliminate unfairness. So the critical question then arises, how do we achieve this dual objective? And here the CERRE report provides this interesting concept that you described in your remarks. It suggests the use of output indicators as a means, among others, of course, among other data, to gauge compliance with the DMA. Now, the primary aim of the DMA is to create opportunities opportunities that complementors and other firms should have the ability to engage with. For instance, the ability to change default settings in closed ecosystems, or the effortless use of non-proprietary apps. This is where, for instance, the DMA can make a difference. However, once these opportunities are accessible by both firms and both firms and users engage with them, it would not be prudent, in my view, to compel users into adopting solutions that do not align with their interests, merely for the sake of enhancing market contestability. The DMA goals, after all, is not to corner Europeans into using the Minitels of the 21st century, especially when the rest of the world is advancing rapidly. The ultimate aim, in my view again, should be to ensure that users unaffected by tactics such as dark patterns, for example, are free to choose services that they genuinely prefer, even if the services are offered by the so-called gatekeepers. Consumers, citizens, do have agency. Thank you.
Thank you very much. Again, I will come back to that because, I mean, I think we would agree on this. That's the role of the DMA is to create opportunity, but I think we think that indicators, I mean, it's always a question of counterfactual. You know, is it better to have no indicator at all, or to have the indicator we propose, and to have indicators? And then the question, as Carel was saying, is what kind of indicators? But we think that in order to focus the mind of everyone, to understand whether the opportunities offered by the DMA are taken up or not is an interesting analysis to do. But again, and I repeat, and I wanted to insist, it's not because an opportunity is not taken up that the gatekeeper has not complied. And there, I fully agree with you, and it's important that you recall this. Yeah. Yeah, opportunity and engagement. Fiona, now, what on process or on indicators, what do you think you like in the report and you like less?
Hello, everybody, and sorry not to be able to be there in person. I have to teach, unfortunately, as part of my job, so I'm in the United States, but thanks for the invitation. The report, as Carel said, has a lot to like in it. I think my favorite bits so far, anyway, are in chapter 3, the discussion about dialogue. I think it's really helpful to isolate, as you do so explicitly, the measures where really there's no need for a dialogue with the gatekeeper and where it might be useful but not critical, and then the categories where it just nothing's going to work unless there's a dialogue. I think that's really important to spell out. And then the implications, therefore, of when the dialogue is necessary and whether that dialogue is supposed to happen before compliance or after compliance. Is compliance starting the dialogue? But of course, then the business users can't possibly be on the gatekeeper doing the contestable things at the moment of compliance if there has been no dialogue up until that point and it's necessary. So this division of activities into these 3 camps has significant implications for enforcement and is just very clarifying, I think, and well written. Another part of the report that I very much like is the incentives for gatekeepers. I think of course, when you write a law, and you're the parliament or other European institution, you have to write the law and say, here's what you must do, 1, 2, 3, 4, 5. And there's nothing about, we'll be a little tougher on you if you're badly behaved and lighter on you if you're better behaved, because this is not how laws get written down. And in principle, we enforce the law just exactly the same for everybody. But of course, realistically, if one is thinking about how to interpret a problem where a gatekeeper and a business user are at odds and can't seem to come together, and that is making contestability not happening, it matters a great deal whether there has been demonstrated good faith attempts by one side or the other side or both sides to try to figure it out. Some of these problems are quite hard. They're legitimately hard. And people of good faith might not be able to get to an obvious good answer quickly. And it's important for the regulator, for purposes of incentives of complying with this law, to be hard on gatekeepers or third parties that are constructively not complying, and be more, I don't want to say lenient, but just more find a path that is convenient for those parties when they are trying very hard to comply and do it right, and it's just, the problem is just hard. And so thinking about the incentives that the Commission could set up to encourage good behavior by all parties, and letting the Commission use its discretion in the way it enforces the law to create those good incentives seems to me to be a really important contribution to the debate. And I hope, of course, that all the gatekeepers are enthusiastically complying. I will say that the previous speaker's remarks about whether we can interpret non-entry and no change in contestability or entry of business users as evidence that the gatekeeper's not complying. I mean, that was the debate as I heard it in Brussels in October. So it's a little depressing that that at least some gatekeepers haven't moved on from that point to more sophisticated ones, or more points that you might bring to a debate like this that indicate that the gatekeeper has moved down the road in compliance and is actually doing things and might therefore have something to contribute that's new. So I'm not sure how optimistic I am at this point, but I think that this section 4 about incentives will be necessary. Thanks.
Thank you, Fiona. Max.
Firstly, thanks for having me, and just to echo the congratulations for this impressive research and this impressive conference at such a critical time for DMA implementation. I think what I like most about the report is the emphasis on the role of third parties in enforcement of the DMA. That has been a major priority for open markets when it comes to our work on the DMA, both because we think that there's a wealth of expertise out there, not just among business users, but among think tanks, consumer bodies, academics, and so on, that can really help ensure that the regulation is enforced effectively and kind of help address the kind of inevitable resource gap that we see between the Commission and the gatekeepers. And also because we think that a closed-door discussion between gatekeepers and the Commission is not going to result in the kind of effective, real compliance that we want to see. And so I think in that sense it's really critical. A couple of recommendations that I'd highlight from the report in particular. I think early engagement is really important, so we don't want to be leaving the discussions until the last minute, until March or afterwards, where we see the compliance solutions and then suddenly, they're not satisfactory for whatever reason, and we have to have this big argument and kind of delay the compliance process that way. So I think, it's already quite late. It's only a month and a half until March, but I think we should be kind of ramping up that engagement as much as possible. I really like the idea that engagement with third parties is used as a way of judging whether gatekeepers are kind of complying with the DMA or not. They should be incentivized to do so, but I think where those conversations aren't happening, I think that should be seen as a kind of negative factor when judging the degree of compliance. And then I also really like the recommendation around the Commission being kind of proactive and transparent in explaining to third parties how they'll engage with the process. I think, unfortunately, so far it's been a little bit opaque and kind of difficult for third parties to understand how they can be having conversations with gatekeepers in the Commission. That's just not our experience, but also other groups that we talk to. And so I think some kind of guidance and kind of a signal of how that engagement should work would be really helpful. In terms of areas where it's, gaps or things, I kind of am a little bit more skeptical about. Kind of touched on this already, but I think the report talks a lot about the role of business users as third parties, but I think there are many other types of third parties who could contribute expertise. I'm sure lots of people in the room would fall under that category. In terms of the indicators, I think it's really important to have indicators that go beyond just process and look at what the actual effects of these obligations are. Are people switching services? Are they porting their data and so on? But I think we shouldn't stop there. I think it's also important to have what you might call holistic indicators that kind of apply to the DMA obligations as a whole, so we can kind of really see, if we're having changes in contestability, in market share, in the emergence of new rivals, which will really tell us whether we're achieving the objectives of the DMA. So I think in your report you call those outcome indicators, but I think those are important as well. And then finally, And we might be talking about something else, you know, using the language differently, but the language around self-regulation or self-execution, I'm a little bit skeptical about. I mean, ultimately the DMA is regulation, not self-regulation. And I think we run the risk if we leave it to companies to kind of define what compliance looks like and then kind of examine that afterwards, that will create a lot of problems for ourselves. So I'd like to see the Commission, you know, I think as it is already being quite proactive in kind of making clear to gatekeepers what good compliance looks like to kind of steer that process. So.
Okay, thank you very much. So let's go to the Commission now. You were just mentioning the Commission. Antoine, what do you like and you like less? And also, maybe if you can react on what you have heard so far, and then I go to Amelia.
All right, yeah, works. Well, it's a lot, so clearly I won't be able to react to all, but what I can do is tell you a bit, you know, my take after reading the reports. Clearly, I like the indicator paper because that gives us input, so very nice. The other one ends with a huge to-do list for the Commission, so I like it a little less. No, but joke aside on the indicators, I think it's really following up in a way we triggered it, right? Because we did a public consultation on our compliance reports, and in this public consultation, we actually specified that we were after that kind of input. Because where we agree is that it's not an easy task, right, to define these indicators. It's also a task, I mean, we in the final version of that compliance report made really clear that our conclusion, we think these indicators are useful, so we want to have them. We want the gatekeepers to provide these types of indicators. We did not go as far as specifying them for now. And the reason for that is exactly the work you've been doing. It's because we want to receive more input. We want to have more experience. So, I mean, the CERRE input is great. We have put it on the gatekeepers to, in a way, make a first attempt at indicators in their compliance reports. We think they have a strong incentive to make them useful. We are not just after any indicators that will be useless and, you know, we have indicators, great, that's it, tick the box. They have to be something that will really help us understand whether compliance is effective, because that's what we're after. I mean, that's our mandate. We have to ensure that compliance is effective. So the indicators will be one of the tools, but there are many other items in the compliance reports. I mean, of course, the consultation of the stakeholders, it's clearly there. That's something that can convince us that a compliance solution is effective. And in the indicators fall in this box. So gatekeepers will have a go at it. I think they should refer to the CERRE indicators. Since they are there and since they were involved, I would expect that they explain why they would not pick up some of these indicators. I think they need to go further. I mean, they need to do their own thinking. I mean, I heard some good ideas from Carel. Why not? Why not having others? And also any other input. Then very important, it's not only CERRE, it's not only the gatekeepers. I mean, this compliance report, there will be a public version, so these indicators, they will be exposed to the market. And that's your point, Max. All the stakeholders out there, so a wider audience, will be able to also tell us whether they think these are the right indicators or whether there is something else to it. That was for the indicators. Maybe a smaller comment. What I like in your list is the ones that really go to the kind of friction and dark pattern. For example, I initiate something, like I want to disinstall a piece of software, but I stop in the middle. I think that's very interesting, because if I wanted to do it and I didn't go to the end, it may just be that it was too complex or something just, yeah, I mean, there was a negative steer. On the DMA process, okay, that's a very wide topic. In general, I must say, I mean, I like your description of positive regulation, but I like it only if you read it together with the possibility that things will go less well and we will get in a world of more punitive regulation, because it's all based on the premises that we are together for the long run. I mean, we will be in this continuous regulatory relationship. As long as there is constructive engagement, as long as we see reaction, like quick reaction to the feedback from us, but most of all from the market, because that's the feedback that matters and that will make the solutions effective, there is trust and there can be positive, how do you call it, positive regulation. But clearly, as soon as we feel that the trust is broken or things are not just progressing, we have a whole array of very impactful enforcement tools, and we will definitely make use of them. A very, very last one on the papers. I mean, there are a lot of very useful thoughts, and really we will all read it. But there's also all these attempts at categorizing and best practices. You also have to see that all of this is new and that the practice is actually just being created exactly now. And on the categorization, again, I could probably agree with most of it, but what I absolutely see is that every question that is put to us has some specificities, and we have often like a menu of options, like a menu of things we can do to enable progress, and we choose from that menu. And there really is, at the moment, a lot of merit in also having some flexibility just to have the kind of tailored solution that really will be effective. But I can absolutely see it as it has been the case for other instruments, that at some point things will be more mature and that will be the right moment to come out with the kind of guidance you mentioned in the paper. But we're also giving a lot of guidance in different forms, but be there templates, websites, meetings, conferences, articles. There is still a lot out there.
Thank you very much. And Amelia, maybe a reaction to what you have heard so far.
Okay, well, it's been really, really interesting. And I thought that I would react mainly on the indicators. I was, as you might expect myself, since I was involved, I obviously like most of what's in there. There's not that much I don't like. What I had expected a bit more concern around, because we had quite a lot of concern about it in the process.
Oops. Yes, we will come back to her. Maybe, Giorgio, if you want you to react to what you have heard so far.
Was it just about how...
Okay. Sorry, there was an issue with your connection, but it seems to be okay now, so...
Oh, okay. Hang on. I've now lost my notes. Okay. Okay.
So you are speaking about the process, but then we lost you a bit.
Okay. So, yeah, so I was... during the process, actually, where we had the biggest pushback and where I had expected some of the concerns to be highlighted today are in terms of just how many indicators there are on the list. It is quite a long list. And indeed, we had an even longer list in the process, and we did really challenge ourselves to focus on what we thought was really important. And you can see some of that in the commentary column. On that, though, and this isn't something I don't like, but it's just a very slight worry, which is that we were also, as you will hear later this afternoon, doing other work streams around data interoperability, choice architecture. And obviously that relates to certain provisions more than other provisions. And what I noted during the process was that where we had those other work streams open, our indicators kept getting more and more sophisticated, more thought was going into them. And so it does lead me to slightly worry whether the provisions that we hadn't focused on as much are quite as well thought through in terms of the indicators that are needed. So I think that, I wouldn't necessarily see this as an absolutely final list, but I think everything that's on the list is really, really useful. I also think there is some potential for outcome indicators. We deliberately didn't get into that, but I think that's what Max was suggesting. And also Carel, I like Carel's idea of tracking malware instance, for example. I just wanted to highlight one thing that hasn't really been talked about that I really like in the indicators document, which is it's really thoughtful about the whole process of both the importance of reporting these indicators to the Commission, but then the value of making the reports public, not least because third parties can then confirm their veracity, but the tension between those two things, because you want confidentiality concerns not to limit what is reported to the Commission, but equally you do want to make as much as possible public. And so there's actually quite a sophisticated thinking in the paper, but I've no doubt that could be taken further about, for example, the Commission receiving relatively granular data from the gatekeepers, but then aggregating that in the public report and perhaps giving third parties their own data or privately on which they can provide feedback. So I think that's quite an interesting aspect as well. So I'll leave that there.
Thank you, Amelia. Giorgio, yes, a reaction to what you have heard so far. And then I will take question. If some of you have some question, either here or online, it's the time to think about it.
Yeah, well, three quick things. The squeaky wheel issue, I mean, obviously a solution cannot satisfy all business users, for example. But I think one thing we explained in the report is that if the gatekeeper explains, look, this solution works for the majority but doesn't work for them, then there is a good effort being made to explain the rationale for making a choice that is not perfect. So I think, you know, lack of perfectly satisfying the third-party beneficiaries is not evidence of non-compliance in itself, but it's a valuable point to think about. In terms of the use of the word self-regulation, and I think the way we put it in the report as well, it's more an active supervision. So the initiative always goes from the gatekeeper. So the gatekeeper should be the one who has the incentive to decide how to comply, but also within a framework of cooperation and of oversight. So it's not a situation where, you know, we don't want regulation, but we want a different type of regulation than the adversarial front. But of course, just to respond to the last point, the possibility for punitive regulation is not excluded in the report. It's just that we think a lot more emphasis should be placed upon thinking about how to do the positive regulation bit, because we all know how to do punitive. And just one brief point on the indicators. I think your point about some of them may not be indicators that the gatekeeper can produce. I think that's obviously going to be important. You know, if we cannot get evidence of how many people uninstall a particular app, then clearly that may not be valuable as an indicator. The other point is that if the indicators are shared across all gatekeepers, and if we see the DMA as being about opportunities and engagement by the end user, and we see that the end user on gatekeeper platform A has a lot of engagement, and for the same things on platform B has very little engagement, then the fact that you have a shared indicator allows you to raise the question as to why it is that the gatekeeper the end user is much more engaged here than there. It, of course, not conclusive. I mean, the report, as Alex has said before, the output indicators are not about compliance, but they're about raising a question by looking at some fairly raw data. And I think the other point I wanted to make, again, the capacity to engage with third parties. Obviously, one does not expect a gatekeeper to engage with all third parties, but you know, if one makes the choice to say, look, we've done an A and B test over 2% of the population, and the result is this is the preferred outcome, then that could be seen as satisfactory. So I don't think one expects engagement with the entire family of business users, then the entire family of consumers.
Thank you. Giorgio, do you have some question? Yes, I don't know if there are some microphone. I don't know if someone can distribute the microphone. I will take all the question together, so please be brief in your question. So question, no comment, and then we'll go to the panel. So there was one gentleman here. Yeah.
Thank you. Sebastiano Toffaletti, representing the European Digital SME Alliance. I have a question for maybe Max or the Commission, whoever wants to take it. What is the right balance, actually, between a punitive regulation and a more positive regulation? What I mean is, based on what I heard from the paper, this indicators approach, this effort-based approach, isn't there a risk that you know, we look into efforts and we don't look into real, actual compliance, effective compliance, representing SMEs here, business users of those platforms, and what we want is effective solutions. We know it is technically possible to make those solutions happen. If we look into too much of an effort-based compliance, isn't there a risk that this is going to be just a tactic to delay the real effective solutions? And while the Commission say, but you're compliant because you're making efforts.
Okay,
isn't there a risk?
We get it.
Thank you.
Yes? gentleman here, and then the ladies here.
Thank you, Christophe Garrity from Digital Competition. So I have a question to you, Antoine, and it's a very straightforward question, but complicated answers. So we are on 6 March. The gatekeeper gives you a report. When you will publish the report on your website, the public version of the report?
The public versions.
Yeah.
Okay.
You will publish your report on the 7th March or later on?
Okay, and then the woman here.
Hello, my name is Isabella De Michelis, and I'm the founder of a small SME IT, and we're working on data portability. The question is the following. We know who the gatekeepers are. We don't really know who the business users are. And the business users in Europe, they're very distract. They do little investment. They're totally incapable of using data, even if they're offered the data. So what is the effort of the Commission to monitor actually the business users, that they're also compliant with being responsive to what the compliance is going to be on the DMA gatekeeper side? Thank you.
Antoine, maybe you may start, because several question was addressed to you, and then the other may complement as they want.
So the first one, on the right balance between the positive regulation and when it gets more punitive. I think it's, in a way, what matters to us is actually to get to something that is effective and to get there in the fastest way, right? So I think we will always have a bit the two options. I mean, right now we don't have the two options. Right now our only option is to actually encourage this positive regulation, because we don't have the enforcement powers. We only get them on 7 March. From 7 March onwards, I mean, when we will be confronted with what could look like a non-compliance, the one option is to flag it and ask the gatekeepers to solve it quickly. If we see a clear prospect that this will happen, maybe that's, I can tell you, it's actually probably much faster. Because, you know, you don't start like from scratch a whole investigation where, of course, like the gatekeeper will always have great arguments, even if they, you know, even if the reality is that they shouldn't. But believe me, they will always produce arguments that are difficult to rebut. So it may be that, you know, not going ballistic with this kind of proceedings, formal proceedings, is the efficient way to progress. In other cases, I mean, it will become clear to us that we're stuck. We're hitting a wall, there will be no progress, and there, I mean, we won't be able to avoid like, you know, the kind of more adversarial proceedings. I think that would be my answer. The second one, unless, yeah, okay, but I take the 3 questions, and the publication of the non-confidential, so I can't tell you exactly, but what I can tell you is that I mean, there is an obligation to have this public version. What I've seen in the past in other instruments is that the first public version we receive, we may think that it's not sufficiently comprehensive. So there usually is a bit of a negotiation between the Commission and the gatekeepers to try to get it to a better shape. So several options, like, let's see. I mean, let's see what we publish and when. But there may be a bit 2 moments, right, with a version and an improved one. And the last one, yeah, on the business users. I mean, the DMA does not impose obligations on the business users. I mean, the DMA tries to create opportunities for them. Where I think your point is valid is that we should probably also think about ways to really make sure that they are aware of these opportunities, so that they actually do act on them and exploit them. That I think Martin referred to it, right? I mean, we will try to do it at our level. I think if the national level, because they're probably often closer from some of the stakeholders, because I mean the one that come to us like the European wide, I mean they know us.
If I may, this is not a question of awareness, it's a question of indicator. You're talking indicators. If you have indicators on one side and you don't have indicators on the others, then it would be very difficult to make an assessment over time whether something has worked because one side has not cooperated or because the others have not followed what it was necessary to actually implement what has been made available. I'm really talking ground.
Okay, sorry, yeah. So I think that goes to, I think whenever an indicator provided by the gatekeepers points us somewhere, I mean, we'll investigate, and that will probably mean going to the business users and understanding what is behind it. And other possibilities that, I mean, some of the indicators from the gatekeepers are actually about business users' behavior. I mean, you know, how many of them will
invest, adopt processes,
exactly, request data. I mean, all of this. I mean, these are
I mean,
okay, we will not organize a bilateral dialogue here.
It's indicators.
So, yeah, okay.
Indicators.
Okay, it's important, but we got the point. So I don't know if there are other people who want to comment in the panel. We have to close in 5 minutes, so please be brief. Max, yes.
So just quickly on the Sebastiana's point about compliance, you know, basically this is a question of sticks and carrots. Where we are now, we're during carrot time essentially. So you know, I don't disagree with CERRE that now, as we come up to the March deadline, we want to be focusing on incentives to comply as much as possible. But I think we need to be ready to pull out the sticks when the time comes. The DMA obviously has some considerable ones, including fines, but also, you know, potential structural remedies, you know, prohibitions on mergers and so on. So I think we need to look at that whole toolkit, and we've seen how, at least in antitrust, fines have not been particularly effective, so I think we should probably be looking at some of those other remedies first. And I think when we are trying to decide whether compliance is working or whether we need to use sanctions, I think we should rely a lot on, you know, I'm going back to the third party point, how people are kind of interacting with these solutions and whether they're working, particularly for business users. So I think, you know, in March, it's fair enough that there might be some technical problems and there can be an iterative process to try and solve those. But I think if, you know, the Commission is hearing again and again from the businesses who are meant to benefit that these solutions aren't working and there isn't a genuine effort to improve them, then I think that's when the penalties come out. So.
Thank you. Carel, George, do you want to add something?
Let me just add, I mean, as a gatekeeper, we are laser focused on implementing the DMA, and I think a lot of people are working in this community hard to make that work. So I think a little bit of trust that, you know, this process is leading in the right direction, and this effort of trying to do that on this trust basis, I think is very much appreciated and helpful, actually, because otherwise you start already get sidetracked. And, you know, from my own experience, I joined Microsoft in the early days when we had this enforcement concept under Article 82 at the time, abuse of dominance. It's a very different dialogue, and it distracts a lot of resources. I think, you know, this positive regulation actually helps people focusing on the target, which is kind of a joint target, and then, you know, let's deal later and get distracted about all these cases and disputes. I think, you know, the approach is the right one to be as effective as we can in terms of driving implementation.
Okay, Fiona, Amelia, do you want to add something?
I think the point about business users kind of being quiet and not sufficiently engaged is a really good one. I'm not personally sure it's for the Commission to do anything about that. I think it's for the Commission to make sure that the DMA is complied with, and also be really clear with business users about what the DMA actually means for them, particularly when business users ask questions about what it actually means for them. But I think there's actually a real role for third parties, and the women in your audience may be a good example, to really think creatively about what the DMA is going to open up in terms of new business ideas and go and sell them to people. You know, there's a lot that the DMA could potentially create, and I think that we're just at the beginning of people thinking innovatively about that.
Thank you. And the last word to
follow up. Sorry,
yes,
Alex.
Fiona and then Giorgio.
Follow up with what Amelia said. I agree 100% with all of this. I think the trick is that the DMA should open up business models where there are not business users today. And if the business user doesn't exist, it's a little hard to know how they're going to engage with the Commission to make sure that the interface is one that they can use in the future. So this is just the nature of this law that we're going to have to muddle through. But I think anything the Commission can do to bring entrepreneurial groups to the table and create common knowledge and tell them about their rights, because there will be, we hope, new businesses that just don't exist today that do spring up because of the DMA.
And Giorgio, the last word.
Thanks. Yeah, just to respond on the balance between positive and punitive. I mean, the theoretical work says you've got to assume firms want to comply, but of course it's about results. So even if you're being just a positive regulator, you're still looking after the result. You're not just thinking, are you doing your best to comply? Are you delivering on the DMA? Article 8.1 says that compliance has to be effective. The question is, do you first nudge towards effectiveness before you punish? And I think to escalate towards ever more punitive measures is more useful than to begin with the stick. So the idea of the report is very much to say, let's nudge first and see if that works. Failing that, we escalate further.
Okay, thank you very much. That was very informative. I think we agree on indicator at least, so that's a good thing.